In April of 2025, they filed the complaint in June of 2025, and you got arrested in June 24th of 25. You posted a $100 bond. I think you spent 1 day there. Then you didn't show up for your attorney pretrial, and you got arrested again on December 9th, and you posted a $250 bond.
Yeah, I already done served 6 months for both these charges. Well, I was in jail for 6 months for that. You told me you would run them both concurrent.
I did, but this was another charge.
No, that's the same one. It's the same two. I only got 2 tickets, and you said you were going to run them concurrent. That's why I'm like shocked that I even had to get post $250 just to come here.
You had a pretrial on July 3rd. You didn't show up. Let's look at another case. This one occurred in April. It didn't get charged until June. And I think what happened is we took care of everything that there was in April. You were gone. And then in June, they authorized this charge. So I think that's what happened. We didn't even know about it when I saw you.
Yeah, we did. Yeah, I told you that I had 2 charges, and you said you run both concurrent, both tickets.
All right, well, let's take a look.
That's why I sat 6 months instead of
6 months where?
Here.
On what charge?
On the trespassing ticket.
You can't do 6 months on it.
I did. I know. For both tickets. You ran both tickets and me fighting with the police or whatever.
Well, there was an R&O charge.
Yeah, the R&O and the 2 trespassing tickets.
Well, let's look at this one. All right, you had a trespass from January of 24. Judge Pattison did that.
First FIR traces back to an incident in April 2025. Although the incident occurred in April, the formal complaint was filed in June 2025. On June 24, 2025, the accused was arrested and later released on a $100 bond after spending 1 day in jail. At that time, the case involved a trespassing charge, along with another related citation. According to the accused, the court indicated that both charges would run concurrently. From this point forward, the accused believed that the matter had been fully addressed and resolved. However, this belief would soon be challenged by the court record.
That one. And he did that one concurrently. Then in 1076, you had another trespass in April of 25. Let's look at my notes. That was June 6th. Defendant fails to appear. All right, that's this one, 1076. And a larceny. Let's look at your felony. Judge Pattison saw you on the R&O, 29 days, credit 29 days. The only 2025 charge you have is this one.
Mm-hmm.
And I didn't run it concurrently with anything.
You were supposed to run both tickets that I got together when I set 6 months for the R&O, because I got 6 months for it, and so you wrote them off concurrent.
That preceded this. This happened, and all that stuff happened in 24.
Right. It was 2 tickets out. That's all I got.
Second FIR emerges after the accused failed to appear for a scheduled pretrial hearing on July 3, 2025. Due to repeated absences, the court issued a bench warrant. Months later, on December 9, 2025, the accused was arrested again and released on a $250 bond. The accused maintains, "I had already served 6 months in jail, and I was told both cases would be run concurrently." But according to court documents, this charge was never formally pleaded to, and therefore was never merged with any other case. This procedural gap becomes the turning point of the case.
We're run concurrently.
Right.
But then you got this ticket in 25.
I've only had 2. I never got another one.
All right. Well, the problem is this one never got addressed. It wasn't run concurrently with anything. You missed several court dates. And so here it is. You've done 11 days in jail on this one. And you've got more than enough money to pay your fine. So you never pled guilty. You never pled guilty to this charge. So it wasn't run concurrently because you never entered a plea. If you plead guilty today, I'm going to give you 11 days credit. I'm going to give you a $200 fine, and I'll give you the balance of your bond money.
I don't know why you told me you were going to run it concurrent. I don't understand why there's 3 tickets. There's only 2 that was given to you.
There were 2 in 2024.
Right.
This was 2025.
Okay. I never got another ticket. Where did I get trespassed from?
Well, let's take a look.
Because I've been trespassed from a lot of places, you know?
Yeah, that's unfortunate.
Yeah.
All right. This ticket was in Sturgis Township.
Same place.
Joseph Yoder.
Yeah, same. It's the same ticket. You're supposed to run these 2 concurrent. It's the 2 that you went to jail for. That's what this is all about. And I already done served 6 months, and you're trying to double jeopardy me now into like something that's not it's just messed up. I ain't trying to do all that.
Well,
I told the last guy when I came here and talked to him in the office that it was a double jeopardy. You guys are trying to get me twice. No, because it says 2024 and 2025. It's like right there at the bus, you know, between them, because I got one then and I got another one right after.
Yeah, well.
And I didn't get no ticket after that. And that's the one I went to jail for because of Joe, because he kept my bike and almost half my stuff.
Third FIR is not a new offense, but an unresolved 2025 trespassing charge that remained open due to missed court appearances. The court clarifies, a 2024 trespass case had already been resolved, but the 2025 charge was never closed, and therefore never ran concurrently with any sentence. The accused argues this amounts to double jeopardy, being punished twice for the same incident and location. Given the confusion, the judge orders further review. The accused attorney is called in, and an attorney pretrial is set for February 6th. Only then will the court determine, was this a failure of the system or a failure to appear?
Well, we're off with a bang. It's good to get back from vacation and start off with a giant clinker, but that's how some things go. I thought I kept your bike so you could get it.
I took the cop over to his shop and asked him if I could get my bike back. Cause I talked to him on the phone. He said, "Yeah, bring the cop over and I'll give you your bike back." And I still don't have it. And I was very polite and nice to the guy. I was not rude or nothing when I got out of jail and talked to him. This is the first thing I did was bring the cops over there so I could get my bike.
Well, I tried to get your bike. There's so much stuff in here, but this is the only 2025 ticket.
Right. It was for the trespassing behind Dunham's or whatever. It's all in one spot.
Larceny, February 24. Arnold. That was Judge Pattison. Attorney Hardin failed to appear for attorney pretrial, due bench warrant after 48 hours. Failed to appear pending bench warrant, bond $250. Outstanding warrant. They ask you if you want to come in today. I can't tell what the heck is going on, but you have a lawyer in this case. You've never entered a plea. You contend it's double jeopardy. I'm going to show. I'm going to get Attorney Hardin in here to help us. I'm going to set an attorney pretrial for February 6th. At 8:30. Need to explore other cases. All right, Mr. Featherstone. As far as I can tell, you never actually entered a plea in this case. You had an attorney, Jordan Hardin, but you missed so many court bench warrants, and then you get your bench warrant, and then you get picked up, and you.
Well, I have a good person to give me a ride to back and forth.
All right, very good. We'll take a look at this on February 6th with your lawyer, Jordan Hardin, here to help us. All right, sir. I'll see you on that day, and maybe we can sort it all out. We have more time to figure it out.